This is to our third in a series of Elder Law 101 Lessons for Life Planning. This program tonight will be taped. Please mute your microphones. The last 15 minutes are reserved for question and answer period. Please type your questions in the chat and direct it to me, to Tracy, and then when we have the question and answer, I will ask Dawn and Audrey those questions. And I'm happy now to introduce our speakers, Dawn Friedman and Audrey Zabin. Dawn has practiced elder and disability law with Rosenberg, Friedman, and Lee LLP in Newton for over 40 years. Dawn is a longtime member of Temple Emmanuel, where he is active with the Bereavement Committee, the Daily Minion, the Inclusion Committee, and the Stars of David program for Jewish adults with special needs. And interestingly, Dawn is a past board chairperson of the Alzheimer's Association of Massachusetts. Audrey Zabin is the founder of AZA Care Management and Home Care in Boston. She's a leader in the field of care management for elders and adult disabled for over 20 years. She has served on the boards of directors for both the National and Local Aging Life Care Association, and she's also a member of Temple Emmanuel. She runs a caregiver support group with a focus on care strategies to enhance quality of life. Through Temple Emmanuel, I offer an array of social programs as well as an adult support group, caregiver support group, and a memory cafe. And if you want information on any of those, just send me a chat with your email information. Before the speakers begin, I want to acknowledge Benchmark. Benchmark is underwriting this series. Tonight we have Gina DiStefano. She is the new Director of Community Relations at Chestnut Park in Cleveland Circle in Brighton. Gina, would you like to say a few words?
Sure, absolutely. Hello, everyone. Thank you all for joining us for another informative presentation with Audrey Zabin and John Friedman. As said before, my name is Gina DiStefano of Benchmark Senior Living. Benchmark Senior Living offers unmatched service across independent living, assisted living, memory care, skilled nursing, and respite care options with 5 local communities, all within the Newton area. For more information about our communities or services, please reach out to me. I will enter my contact information into the chat. Without further ado, I would like to turn this over to Audrey and Dawn.
Thank you, Gina.
Thank you.
Welcome, Audrey and Dawn.
Thank you. Thank you, Tracy and Gina. And nice to see everyone here this evening. Dawn and I are going to have a conversation tonight about legal and financial planning in terms of the onset of what can be some pretty scary and difficult diagnoses. Whether it's Alzheimer's or other dementias, no one expects these diagnoses. Sometimes they sneak up on us and sometimes we're not ready for them. So we thought it would be interesting for you all to hear a conversation about how to plan for that the best we can. It might be helpful to first discuss the diagnoses of Alzheimer's disease and related dementias, because for the purposes of our conversation today, we're going to be discussing the early stages of Alzheimer's disease. Many of you may know that Alzheimer's is broken up into 3 different stages: early, mid, and late stage. And for our discussion tonight, we're going to be sticking exclusively to the earlier stages of Alzheimer's disease. The other area of Alzheimer's disease that we'll take into consideration tonight during our discussion is what we call early onset, not to be confused with early stage. Early onset Alzheimer's is a diagnosis of Alzheimer's under the age of 65, early in someone's adult life. The other thing I wanted to point out to you in terms of diagnoses and diseases is that, unfortunately, this kind of abrupt planning is not limited just to Alzheimer's disease. That Alzheimer's is just one kind of dementia. There are several kinds of dementias, and in the 20 plus years I've been a care manager, I think we've gotten a bit better in being able to diagnose and distinguish, but certainly there's Lewy body dementia, normal pressure hydrocephalus, NPH dementias, vascular dementia, frontal temporal lobe dementia, sometimes called Pick's disease. Parkinson's, we know now, can carry a dementia component, as well as Huntington's disease. So there's several kinds of dementias. And to be clear, what dementia really means is it has an impact on your cognitive capacity. So there's something going on in your brain that does not allow you to process information, to think the way you once did. And early stage Alzheimer's and early onset Alzheimer's, they typically move slowly, the disease process, but not always. They don't all develop, and not everyone's disease develops the same way. So it's very important that you remember that you're not comparing yourself to other patients, that you realize that everyone's disease process is different. Dementia's symptoms usually, as I mentioned, do have an effect on your cognitive capacity. And I think probably the most obvious symptom is being unable to remember things, that you're no longer able to remember something that just happened, to make a new memory. And memory loss is usually the first sign people around you will notice as the first sign of a possible dementia diagnosis. But you know, that doesn't always mean you can't make decisions or that you don't know what you want. It does mean that you need to be proactive in your planning, but it doesn't necessarily mean that you're not a good decision maker for yourself. And I think this is where we're going to have our conversation with Don to begin with. The conversation, Don, about decision making when you have a kind of dementia. What does it mean? We've often heard the term here of substituted judgment and decision making with legal decisions. Can you speak to us a bit about the legalese of this definition, please?
All right, good place to start. You know, and this is particularly important in early stage because, as you'll see, there are many steps that you can take, protective steps, proactive steps on legal and financial and benefits issues that you can take yourself if you have the capacity. If you don't have the capacity, if you have at least named someone, given someone authority to act under a power of attorney or a healthcare proxy, as we'll discuss, then things can go forward. If you lose the capacity and haven't made these other arrangements, then things get very, very difficult. I'll explain some of those difficulties as we go along. But let me take the step back and put this whole decision-making idea into just a little bit of a bigger context. And the idea of being in control of yourself, of your life, of where you live, how you live, where you live, whether you're at home or in assisted living or whatever you decide to do, is a very important feeling and sense. For many people, it's societal, it's cultural, it's autonomy. I want to be in control. People, if they can't drive their cars anymore, it's a loss of control that really hurts them more than the difficulty of transportation. On so many other ways, it functions the same way. So the law is built on this, the importance of autonomy. If someone is beginning to feel the early stages of some of these difficulties, whether it's memory or concentration or attention or many other ways that these cognitive deficits can begin to be felt, they begin losing that ability, or they continue making decisions but without taking appropriate factors into account until they really begin to get into trouble. So there's no final, we talk about people being competent or incompetent, capable of decision making or not. There really is no fine line. We're all, everybody, even without any diagnosis of anything, is on a continuum of an ability to really think through. Some people really use foresight and analysis, and they think about what happened in the past and what happens to other people. Other people act more on the spur of the moment and on their impulse. But we're all on that kind of a spectrum of how seriously we take facts underlying our decisions. And the fact that a person has a diagnosis isn't any kind of a disqualification from still being somewhere on that spectrum of normality.
Right.
We don't, because a person makes a bad decision or makes a bad decision every week, we don't necessarily jump to the conclusion that he needs a guardian and can't make a decision. There have been leading court cases on this where people made really self-destructive decisions about refusing medical treatment that the doctors felt should plainly have been done. A leading case on this had to do with a woman with a gangrenous leg condition who wanted to refuse surgery. She had a history of depression. And the case went to court, and she said she didn't want surgery. Guardian was appointed, and the guardian didn't know what to do. Doctors are telling her she's going to die, and she's saying, I don't want it. So the court decided ultimately that, that she had, in her case, she had the capacity to make this decision. Maybe it was the depression was a factor, but depression could be a factor with many people. The issue was whether she understood what the impact of the decision would be. And she faced that, talked about it, and that was her decision. And the judge said, well, that's her decision. I can't find that she's incompetent just because she's making a medical decision that everyone else in her family disagrees with. So we see this playing out in all kinds of ways. And there's some things just some kind of benchmark things kind of not to think about and to think about in the context of this sort of assessment.
And Don, what would some of the tools be for people to think about developing as well?
Right. All right. So this is something that there's actually, now I'm going to be mentioning there are two papers that I issued that put out in relation to the program. And hopefully everyone has them. If you don't, put it in the chat to Tracy that you want it. Give her your email address if she doesn't already have it, and she'll get these to you. And I'm emphasizing it because the subject matters we're going to be going through tonight are numerous and complicated. And we had to make a decision about whether to just talk very fast and make it impossible for people to even take note of what I'm saying, or try to focus on some key factors, relying on the paper for a reference for people to go back and look at more detail, not get too complicated with the talk, and try to stay at a higher level with the talk. The detail is there, but it's in the papers. All right, so the papers go into this pages. There's one whole paper on competency and capacity where I go into this in great detail. And basically say you have to think about the decision, the kind of decision that's being made. A person might be capable of making a decision about going to a baseball game out of a group residence, but not be capable of making a decision about medical care.
Right.
May be able to make a decision about routine medical care or routine dental care, but not be competent to make a decision about different alternatives for cancer treatment. So same person, different situation. Also, we think of this cognitive ability as being something kind of hardwired with people. And to some extent, maybe it is. There's neurological things happening.
Right.
But there's an emotional component to decision making. It's very important. If a person who is extremely tired or in a completely foreign environment is going to have a much harder time showing that she understands what's going on and making a decision than somebody who's in an optimal situation. You have to think about if they've been on medication that can affect their attention and concentration. when were they on this medication in relation to the decision that's being made? Many, I'm sure, have had experience with yourselves or relatives in going into a hospital and getting completely flustered and to the point of hysteria, literally. Being in such a foreign environment where the lights never go off and there's no night or day, and people trying to present a competent presentation in that sort of a situation are really at a loss. So there are a lot of things to think about, a lot of ways that you can structure the situation in a way to really make the most of the person's ability. Now, a few other guidelines. First, the fact that there is a diagnosis of Alzheimer's or minimal cognitive dysfunction or any of these other kinds of things that you hear about today isn't itself a disqualification from being able to sign a durable power of attorney or a healthcare proxy. You can't jump to that conclusion. Just as you can't equate bad decisions with incapacity.
But Don, it would be.
You should not underestimate capacity.
What I was going to say is it would be important for you to have, if you do have these diagnoses, it doesn't preclude you from making some of these decisions and perhaps planning to have a healthcare proxy or a power of attorney.
Right. The first, it should be.
But it's important for you to do it sooner rather than later.
Right. The first signal, really, the thing is that we do durable powers of attorney and healthcare proxies for anybody who comes in the office for a will. It might be a young couple who just had their first baby and
Yes.
they want to sort of get something assembled as to who the guardian of the kid's going to be if, God forbid, something happened to them.
Right.
But we have them do a durable power. There's no
Absolutely.
imminent need for it, apparent need for it, but you never know. So if a person doesn't have it, or if you're not sure that they have it, and they're beginning to show any kind of signs of difficulty, if they've lost a job because of difficulties with their concentration, or that's the time to really hone in on this issue, get them to talk to somebody, and get the paperwork in order. They don't have to start transferring, they don't have to do anything major.
Right.
At least put the mechanism in place so that decisions can continue to be made even if they get worse.
Right.
By signing the paper, you're not giving away your ability to control your own life.
Right. I mean, the doctors that I do work with, that's the first thing now that they ask their patients, do you have some of these tools in place for when you will need them? Because the next thing is if they don't have them in place, correct me if I'm wrong, but I think then if they can no longer make decisions, then the courts come in and do guardianships and conservatorships. Is that correct?
Right. If a person can't, if you show up at the bank and you can't sign papers, the banks are alerted to all kinds of things about this now. They're very cautious about people signing things when they're not apparently aware of really what's going on.
Yeah.
Lawyers, if they take notarizations, have to do it on the basis of the lawyer's assessment that the person understands the situation. So if you lose this chance, either you can't go through with a protective strategy you would have otherwise done with the house. You can't write a will that has a protective trust for the spouse. You can do that only by going to court, having a guardian appointed or a conservator appointed. These are expensive public procedures. In a time of COVID, they are very, very slow and difficult if you can get them mounted at all. The courts are functioning at some level, mostly on emergency cases, but it's just very, very difficult. Many of the laws require in-person hearings. They're working around that with Zoom, but it's not going well at all. And it's expensive and cumbersome and inflexible. With the durable power of attorney and healthcare proxy, these are broad authorities that give you the chance to do it.
And they're usually family members. Often guardianships are stranger attorneys who are appointed by the court.
Right. If there's conflict in the family, you don't get to choose.
Right. So it behooves everyone with the diagnosis, even if you're not demonstrating any loss of capacity, to get these tools in place. Now, what happens to someone, Don, if they're recently diagnosed with a dementia like an early onset. And maybe they can't drive anymore, but their spouse drives them to work. They can still work. They can still carry on and work. How is this handled in the work environment today?
Right. All right. Yeah. This has happened a number of times. It's not only with younger onset Alzheimer's, but Parkinson's, other
Others.
MS, other impairments that tend to hit adults in middle age and before they really get old. And it's a difficult situation. And quite often, the first contact I'll have with the person may actually relate to the work situation itself. This is what the diagnosis is. I think I can still do the job. I think they're going to fire me. What are my rights? Or I really feel I should stop working. What can I do to get my benefits, work out something with the employer, go on short-term disability? So we really try to work hard with the person, with the family, with their advisor about their decision about whether to try to continue to work or not. Some people, it's evident, that they can't and they know it, and we sort of skip that discussion about accommodating the workplace. But for many people, they still want to, or there's another year to go before they qualify for a special pension program or early retirement, or they just really need the revenue and can't give it up and switch to disability until they absolutely have to. So if we're advising somebody on continuing to work, there are a number of tools that we can use. The Americans with Disabilities Act and the state counterparts is a major component of that. If a person still is basically able to do the job, but needs some accommodations in scheduling, in how the work is organized and presented, in having aids and memory assistance and devices to help keep track of things and keep on top of things, even some extra supervision and meetings. These are things that the law requires be provided if they're requested.
Under the Disabilities Act.
Under the Disabilities Act.
Mm-hmm.
So it's a powerful tool, and we often can really stretch things out. It doesn't give a person, just the disability itself doesn't mean that they can't be fired. They still have to be able to do the job.
Produce.
But if they can do the job with accommodations, reasonable accommodations.
And then what happens so then tell me if someone were to eventually leave work or leave work early, what happens to their health insurance, IRAs, their 401ks, etc.?
Yep. All right. Well, first, let's look at the things that relate to the workplace itself. There are sort of stages with this. There might be a period of time when you ask for medical leave, and there are statutory provisions relating to a request for medical leave while you're still trying to figure things out or to get yourself recollected. There is the Family Medical Leave Act is the primary federal law relating to that. There are also even some of the benefit programs relate to people who are working to some extent. Common Health, I'll talk more about that later, is for working adults and can be under 65 as well as over. Wage continuation programs at the workplace, these vary so much with different workplaces as to how long they may just continue on wage during a leave. Severance packages can be negotiated even if there isn't a severance provision in your employer's booklet. Unemployment compensation can be thought of and evaluated as a way of having some residual income after you leave. If a person is in a situation where they can't do the particular job that they were doing before, but they still have a capacity and can say honestly that they have the capacity to do some work, then it's valid for them to apply for unemployment compensation if they're forced to leave work.
Wow.
So short-term disability insurance, these go to the benefit plans within the company. Most companies have some sort of short-term medical leave or short-term disability insurance programs. Some have long-term disability programs. So what we do in looking at these things with the employee is evaluate, often with the human resources office, to really make sure we understand all of the options and how the person can really work to get the
To
most.
get the benefit of all of it.
Yeah.
Yep.
Health insurance is another major issue.
Yes.
Sometimes the employer will, particularly if it's a medical leave situation or disability insurance situation, that you can stay on your benefits during that period of time. It's when you have to always have in mind the insurance coverage issue. Clearly, you're in a different situation if you
Right.
have a working spouse who's covered in this younger situation. There is the COBRA provisions. There's both state and federal. This has to do with the obligation of the employer to offer continuing health insurance to the employee for 18 months and then another 11 if there's also a disability claim. It can be expensive. The employer can charge the full unsubsidized group rate that is given by the company. Can even add 50% of that as some sort of a, supposedly a administrative fee or something.
Cost,
Most
yeah.
of them don't do it
Yeah.
that harshly, but that's, so these are all things that we look at. Looking at insurance coverage for the spouse, converting a private policy or group policy at the company, like with Blue Cross, converting it to an individual policy as a way of bridging. The Massachusetts Health Connector, the Obamacare program, the American, has a number of options for people who are in this situation now, can't be denied coverage because of this pre-existing condition that everybody knows about. They can't be denied coverage, and that's a whole exploration in itself. You also raised, and that gets us to our next topic, really. So beyond the benefits issue, sort of what can you do with your own stuff?
Right, right. That's
sort
always
of the next
confusing.
Right. Now, I mean, you have savings, and that's sort of self-evident that if you need it, you can tap on that.
Right.
Issues about accessing IRAs and 401ks and retirement accounts gets more complicated. There is, if you're disabled, even if you're under 59 and a half, 59 and a half is when you can start taking out retirement accounts without a penalty. There's ordinarily a penalty under that age, but if you're disabled, there's no penalty. It's still taxable income,
but you don't pay a penalty for it.
You don't pay a penalty. And if you're not working, then you're going to be in a different tax bracket. The tax issue is different from when you were working full time and wouldn't think about tapping these funds. So there are other provisions relating to withdrawals. You can even withdraw more for unreimbursed medical expenses, or depending on your statistical life expectancy, there's a larger amount that you can withdraw without penalty. There's more about that in the paper.
And I know that as younger people, we will often think about accessing a home equity line.
Yep.
Because it's most accessible to us. But I was wondering about that in terms of being disabled and then reverse mortgages. And then, it's when you're younger and you tap into that, your whole thought process is you will pay it back at some point, but not.
Well, even qualifying for it. Fine. If you're disabled and your spouse is not working, then qualification for loans is difficult. If you are a homeowner, though, at least you've got that equity, and there are different ways of tapping it. My experience is that with smaller banks, local banks often have a better crack at getting in, even if income is somewhat reduced. The reason for that is that larger banks tend to they process the mortgage and sell it. They don't deal with it over time, and it has to meet certain standards for them to sell it. Smaller banks are more likely to hold and manage the mortgages themselves. They're aware of the local situations, may be aware of you. You may have an account with the bank or put an account in the bank. So it's a different kind of relationship. But refinancing, if you have a mortgage and there's still a little bit of it left, you think about refinancing to raise additional cash. The rates are very low today, and this could be a way of accessing some cash while you can before you lose the ability or before the spouse also retires.
Right,
Um,
right.
Home equity line of credit is a very convenient way of doing it. Same credit issues apply. But if there's a big spread between the mortgage and the value of the house, then it's a good bet. It may limit you to say that they're not going to loan you more than 70% of the value of the house.
Mhm.
They're still safe with that, but that can be a lot of money with
But
a
that
house.
could be.
Let me say a word about reverse mortgages. There's
Yes.
a lot on this on CNN.
You see it everywhere.
all the time with famous actors. I would never say this if it weren't good for elders. I don't want to. This is something to explore, except there are a lot of downsides to it. Typically, is for a kind of a fixed term. The expectation is that after 5 years or 7 years, you're going to be out of the house. You'll be in a nursing home. You'll be somewhere else, and they really want the house back at that point. The upfront costs are very high. There's they'll quote you some kind of internal interest rates,
Yeah.
but you're paying a lot of money for it upfront and then over time. It's actually, the government allows it. It requires that you go through a counseling program
Right.
with independently trained people.
Right.
It requires before you can sign this thing.
Right.
You go to a mortgage, you go to a bank and get a mortgage with it. Here you have to be counseled. So that says something. So I don't know. We've helped clients evaluate a number of these over the years. Really, I was talking to my people today. We really can't remember one that actually
Went through with it. Yeah.
Completion. Yeah, they went through.
Yeah,
it.
I think
It
I
just
had
doesn't-
one in 23 years who actually went through with it.
Yeah.
Yeah, because it's not
So,
a
all right, so
good
that's-
alternative.
Yeah. So
that leads me to the other questionable alternative often, which is long-term care insurance. And of
right.
course, people ask me about that after they've been diagnosed, right? And we
Right.
know actually that's not the time you can buy it. And the other thing I learned from you, Don Friedman, over the years is that I think, once you have it, you really want to use it and not save it.
Right. Right.
And
Let me say one word about the
go ahead.
Yeah, I'm sorry. No, I was
No,
going to say
please.
about the purchasing or
Yes,
so have had many situations where people actually did get a policy early. They got it while they still could, but it wasn't much of a policy. But if you look at the policy, often there are built-in options for buying additional coverage without medical qualification.
oh,
So you really have to look. Because it's a $150 a day policy, don't discount it completely.
Okay.
It's worth taking a look at. But the point Audrey was making is that we've had lots of clients with long-term care insurance. I can think of only a couple of occasions where they've actually used it all up. It doesn't happen. I think partly because today people stay at home longer. There are more home supports, community supports, people like Audrey working in the community settings to help keep people at home with home care and so forth. So they stay longer at home. Then there are many options. Here we go into the assisted living programs,
right.
and congregate care and so-called independent programs that still provide meals and a lot of assistance. So people will tend to be at home longer. They'll go into one of these other intermediate steps, or they'll try living with their kids for a while, given them more community supports.
Right.
When they go into a nursing home, I don't know the statistics, but my sense is that it's a much shorter time than it certainly was, 30 years ago when there was nothing in the middle, when there were no home community supports.
Sure.
Where people got even moderately sick and went to a nursing home and then might stay 5 years. That just doesn't happen today.
Right.
If they're in a nursing home long enough to get on hospice, it's sometimes unusual. So the point is, the other good thing about the policies, the more modern policies, is that they can be used for things other than the nursing home, for home care and for assisted living and for, putting in ramps and doing, even physical things at the house
And care management now.
and care management.
Yes, right.
To really put a system in place, a set of really comprehensive supports to keep people supported at home.
That's right.
If in fact you use it up, you use it up. I mean, it's better you use it up. I mean, using it up later isn't better than you leaving it up, using it up earlier.
Right.
You use it up later, and when you're in a nursing home, then and you run out of money, you'll go on Medicaid. Medicaid covers the same nursing homes as their private pay. Same rooms, same dining room, everything's the same.
I learned that from you.
Oh yeah. It's by law, but it's really so big place, the Hebrew Rehab or whatever it's called now, senior in Rosendale.
Hebrew Rehabilitation, yeah, HSL, yeah.
HSL, Hebrew Senior Living in Rosendale, the big high rises, 700 beds in that place, something like that. I was talking some years ago. I was talking to the finance guy there on a Medicaid application issue, and I was just talking about this issue. He said, "Look, at any point in time, 70% of the people in that facility are being paid for by Medicaid.
That's
70%.
Right. Absolutely.
The 30% is just people that will come in, kind of mostly transitionally. They come in privately for a while,
and they're transitioning
and they're staying
too.
a long time, and then they go onto Medicaid.
Right.
So he said we could not function without the Medicaid system. Right. He said if we tried to get cute and tried to pick people to come in or sort of give preference to people on private pay, and word got out, we'd be dead. We couldn't, ethically, we would never do it.
I don't think you can do that.
But even looking at just the finances of it, it can't work.
Yeah. So we talked a little bit about Mass Health now in terms of benefits, but, before now, at least, there are actually some community benefits, right? Before you get to that nursing home stage. And, I wanted to talk a bit about benefits versus retirement age and Social Security and how all of that kicks in, because I think that's sort of the next step in this process. Right.
And this is a major issue with the younger onset cases, particularly. Mm-hmm. I put in the last page of the paper as an appendix, I put in a chart that lists the minimum age of eligibility for selected programs for older adults. And I did it not, it could be a reference for you, but I really did it to point out how many of the programs that elder law people and care management people rely on for real elders, people over 65.
Right, just to take care of them.
To take care of them. How many of them are not available for people who might be clinically identical, but because of an earlier onset, just aren't that age yet.
Yes.
And you'll see that many of the major programs, 60 is the minimum age for enrollment in those programs. This is particularly in the community. If you're in a nursing home, there's no minimum age for getting into a nursing home.
No.
So they sort of flip this on its.
But that's not how we want to live these days.
No. Right. We want to be able to keep people who are 58 and have Parkinson's. There's no reason why they should be treated differently than somebody who's 60 and Parkinson's.
That's right.
It's an age, it's an age distinction, an age difference without a meaningful distinction behind it, meaningful reason behind it. It's just, I'm assuming it was budgetary. They figured they could stretch it this far, but not farther because it would involve too many more people. But we've been sort of stuck with these ages as if they made sense for something.
Yeah.
So, right. So I'll talk about some of the major programs. Social Security disability, I'd like to focus on both because it is available for younger people and because it's linked to Medicare, linked to insurance.
Yes.
And people can apply to it even if they're just, if they're 60 or even 62. Mm-hmm. At age 62, you have an interesting choice that you can make with Social Security. You can apply for early retirement. This is where you don't have to prove disability. You just have to show that you're 62 and have worked enough and covered employment and so forth. And they'll start sending you checks. The checks are substantially smaller than they would be if you were at your full or normal retirement age, which is between 65 and 67, depending on your birthday. But it's, there is that difference. It's at least 20% less. And then that's
Yeah,
a
it's
permanent.
substantive, yeah.
It doesn't go up again at age 65. So I've had many people at 62, especially if they have a diagnosis of something, at least consider filing for disability insurance for them then, or at 61, any time when it first becomes appropriate. If you are approved for disability benefits, your benefit level will be really the same as it would be if you had waited until your full retirement age. So it's going to be 20 or 25% higher than with early retirement.
Okay,
And if you project that over 10 or 12 years, that's a huge difference.
sure.
The other thing it does is gets you on Medicare earlier. If you apply for Social Security disability at age 60, you'll be on Medicare at age 62. And if obviously you're not working now, you're applying for disability benefits, you may not have your health insurance, you may be your income may be too high or your assets may be too high to qualify for highly subsidized policies. But you'll be able to get onto Medicare, and you just need to cover yourself privately to bridge that 2 years.
Right.
So it's really important to at least consider that. The rules on how you assess disability are different for older people than for younger people. They're spelled out that way in the rule book. They're not going to assume that you can be retrained at something at 62.
But what if you're diagnosed at 60 with early onset, you have a family and you have kids in college, presumably you would have kids in school.
Yeah.
Could.
Yeah. Well, this is it's a matter of substituting some income and insurance coverage. Depending on the age of the kids, there are provisions, and this gets much too complicated. I spelled some of it. There are monthly cash benefits under different circumstances available in addition to the worker, to the spouse and to young children.
Good. Yep.
Still in high school, or disabled children. A spouse who's taking care of a disabled child.
Yes.
Spouse who's taking care of a minor child.
Yes.
There are sets of family benefits, a circle of things that are available under Social Security that really I think are not well utilized.
Don, if a family has this kind of a situation, do you recommend that they do see an elder and disability lawyer, that it saves them a lot of time and that they gain a better understanding about how to do this? No?
Yeah. Well, the people who understand this are for people in Social Security.
At the office.
Yeah, at the office.
Yes.
And I really have found you can do this now by phone. You can set it up. They'll get into your records. They'll give you, a lot of it is computer driven. It's not you're relying entirely on how much of the experience of that particular worker is. But I did, when doing my own with my wife, we did both. I mean, I did my own analysis. We went to Social Security, confirmed, except for one point that actually came out better with what they said than I had to do in terms of a timing issue. So, it was, I think you can always benefit from that hugely. I find that the experience of social workers in different fields is kind of variable on this. You will find social workers or counselors in agencies who are very focused on benefits issues and applications, and most don't. I mean, they really don't. My wife taught social work school for 28 years at BU, and this is always an issue that I kept raising with her: is that why don't I ever find recent graduates know anything about benefits?
Right.
It's just not part of the program. It's not part of the program.
It's not part of our program. Exactly. Exactly.
The idea of it.
But I think it's very difficult and confusing for young families who, if you have an early onset in particular,
Yeah.
No,
I think I think there's a good opportunity actually to make the team point. There are the things, as we started this discussion, Audrey was focusing on the sort of the clinical aspects of it. When you read the material, we talk about the different context in which a younger onset case arises, where there's maybe a working spouse, so family income may still be too high for some programs.
right,
There may be minor or dependent children. Person may be still working. There are a lot of issues, the vocational, social, personal, that really kind of scream out for some sort of personal assessment around the diagnosis issue and sort of helping you reframe a little bit your life goals or what your goals are for the next period of time. There are just plain tax issues. I think to have typically people may have an accountant, so they rely on for tax prep, and that's all. An accountant or maybe somebody else in that firm may be much more oriented toward tax issues that come up in this context, like how best to use your retirement accounts. How quickly should you draw them down? Should you draw them down before you draw your cash down? Those kinds of questions. There are financial planning questions.
Right.
Now, this doesn't, and there are legal, the issues, the things I've been talking about. It's not that this knowledge base is spread over a number of people. I think that it's in professions. What I advise people to do is try to identify people who, from time to time, and as issues come up, can interrelate on and really figure out how best to handle this stuff on a comprehensive basis. But I think having access to a lawyer and to an accountant and to a care manager is really key. You don't want to have to be starting with somebody new every time you turn around.
Right. Who knows this ongoing story.
Right. It can be at a very low burn. It doesn't have to be a big investment, a big project, but to sort of establish connections with people early on, I think is very important.
Because, for example, Don, veterans benefits it's a perfect example whereby there's some great benefits and entitlements for seniors or patients needing supportive services, either to live in the community or if they need to move to assisted living or nursing homes. But the programs like aid and attendance, for example, are a specialty that I just would not, as a social worker, ever try to counsel someone on, except to find them someone who can.
Right.
And I do think that there are a lot of state benefits that are available, but people don't always know about them, and they change quickly.
Right.
And the application process changes quickly as well. So
should we?
We have about 10 minutes left.
The Medicaid, should we try to talk a little bit about Medicaid?
Yes. So why don't we move on to Medicaid or Mass Health?
Yeah.
Because I think that's a big question always.
The article mentions Social Security Disability, SSI, veterans, the Massachusetts Home Care Program, which I think also is underutilized in this state. It's an
Common Health, yep.
And then Mass Health or Medicaid, same thing in Massachusetts. Medicaid is the sort of the national name. Mass Health is the local name. That said, this is called a state federal program. Federal guidelines structure it, but states have a lot of options into what they decide to do. So the program is going to be different from state to state. Massachusetts so far has been very, very aggressive in using this program. The way it works federally is that if the states do what they're supposed to do under their plan, under their agreement with the feds will reimburse them 50% of the cost of providing the service locally. Other states that aren't as wealthy get a much higher percentage. Mississippi is 90%. So that's how that works. But the states can decide either on just a basic core of services, which must include nursing home services, for instance, or it can opt for an array of things. And Massachusetts has really gone gone for the array. This is
Yes.
Mass Health is really undergirds not only elder services, but also much of disability services, even group residential services at the state level for people with developmental disabilities. It's a broad, it covers rehab and a host of other things, even assisted living to a degree. Um, so it's a key program.
I know that people are really interested on how to qualify for it and what they do with the assets they have. And,
Right,
you know, what we know is the 5-year look back,
right,
you know, all of
right,
that.
right. And there are 3 or 4 pages on this in the
Yep.
material. I'm not going to try to go through all the different cases. The problem is that the rules are different depending on whether you're under 65 or 65 and older. They're different if you're married or not married. And they're different if you're living in the community and are relatively okay, you know, don't have, maybe disabled even, but don't have such serious health problems that you're thinking about needing a nursing home. Or the other category are people who are in nursing homes or who are so disabled at home that they would qualify for nursing home placement.
Yes.
So there are different rules that apply and different services that apply to all of those different subgroups. Fortunately, the state now has a unified application procedure. There's one set of forms that you fill out, and they sort of, the state figures out where you might fit into this, you know, system of things. But you do that, you know, when you've made a couple of decisions. One is that you sort of settled on what services you need. You know, don't make Medicaid your target. You know,
Right.
Medicaid is a means to an end. Focus on what it is you think you need, and then the question is, well, can I get Medicaid to pay for this? How much of it can I afford to do myself, using the equity of my house, using my IRAs? And can I either now, or can I sort of work things out so that over the next 3 or 4 or 5 years, I'll be in a position where I can be on Medicaid and still be able to protect my house or protect my spouse or leave something for my kids.
Right, because people do want to protect their families if they have. So for a good example is, I mean, what do you do? Can you put your 401k or your IRA in irrevocable trust or special needs trust? I mean, what are these, people ask these kinds of questions.
Right. There are things that, I mean, the law the law has some relatively generous aspects to it. It doesn't, this is back in late 80s, 85, the law incorporated a number of provisions to avoid the impoverishment of the community spouse. That was the phrase in the statute.
Yes.
And, you know, so there are a number of provisions that relate to that allow the couple to keep a certain amount of assets, to keep the house, now to keep the house of any value in the name of the community spouse, as long as the spouse is still their residence. There are a host of provisions that deal with special situations, particularly if the couple has a child who is a minor or actually under 21 or who is disabled. There are transfer provisions. If the house is co-owned with a sibling, there are things you can do. You can transfer to the well spouse. If one spouse is sick and one isn't, you can move assets to the well spouse. You can also do a few things with trusts in the context of your estate plan. You can set things up so that if one spouse dies, assets can be held in trust for the other spouse in a protected way. Your ability to transfer and use trusts during lifetime is really very restricted.
It is. What about special needs trusts?
Special needs trust goes to the question of the disabled child. If you have a child who's under 65 and is disabled, you can transfer assets either to the child directly. Child may be disabled but able to manage his own funds, or in trust for the child. It's called a special needs trust, pooled trust. There are several other kinds of trusts that can be used in that context. But you can very often you can end up in a situation where at least you know, identifying key family needs, surviving spouse, and my kids are basically sufficient except for this one that is really a problem. I'm concerned. You may need to sort of hone in on what you can do to the maximum extent that you can to protect the people that you need most to protect. You may end up having to make some real compromises in that regard.
I have a question in the chat. Someone would like to know if you have a recommendation on how to choose a legal and health guardian. Perhaps a power of attorney and
All right.
guardian.
All right. Well, all right. That was the concern, particularly about health, though. It sounded like. So
Yes.
focus on the healthcare proxy issues then. All right. So here, first, it's a key to understand that you're free to choose anyone you want. Nobody has a right to be, and it's not the spouse, not the oldest child. Nobody has a right to sort of fall into this role. It's up to you. And there are typically people named family members, but there may be reasons not to. They may not have family members who are appropriate for this.
Yeah.
They may have relatives who are too distant and they don't have a close enough relationship. Even within a family situation, there may be some really delicate issues about who to choose.
Right.
It may be that one of the children is just better experienced in dealing with, maybe more practical in dealing with medical matters than others. It may be that there's a concern that if God forbid, if the healthcare agent is in a position of having to decide at the end of your life whether to stop the cancer drugs, or to discontinue treatment or not to treat because you're so close to the end, the parent may very well have a concern about the sensitivity of one child and what either the child's inability to make that decision or what it would do to him or her if she did make it.
Right. That's right.
Discontinuing care.
Right.
So there are a lot of sensitive issues involved in it. Availability is a critical issue. The healthcare proxies, particularly dealing with medical matters. Financial matters, it's easier to deal with over the web. So proximity is important, availability, time.
Right. And your breadth of understanding. When I first started my practice, I did do work as a legal guardian. And my availability was very important because doctors need to call you anytime. My availability to access the patient with frequency was always important. And my ability to make, in this case, professional ethical decisions. I'll often have adult children who might be too emotional, and an elder will say to me, they're too emotional to make these decisions. I need to find someone who's not. They can't manage these decisions for me. But I do think availability is very important, to be close, especially in this environment. It's not helpful to be long distance.
People often think that they need to name someone who's much younger. It seems to be kind of the default setting, And no, I can't name my brother because he's my age. What's the point? If your age is 104, maybe then you could say, what's the point? But for many people, it's I think you have to look at these things in the context of where you are now and where you're going to be in the next few years. Don't think long term about who you're going to name. You can change your mind later.
And Don, is it advisable to have a primary and a secondary? Some people do that.
Yeah, no, we always advise it. We do 3.
Okay.
Suppose we've done 4 when the feeling is that I want to include all my kids.
All my children.
Yeah,
but,
I don't want to be excluded.
Right. But most people have more than one person.
Yeah.
Yes.
It's important because it's
that's right.
The person who's named first. It's different from like being the executor in a will, where if you're named first, you're not available. There's this whole procedure for getting to the second person. This is what the law says, is that if the doctor can't reach the first person in time to answer the question that he's looking to answer right now, whether they go ahead with the surgery, you can go immediately to number 2. It doesn't have to wait for a resignation or prove unavailability.
Right.
One phone call is all they'll do.
And in this health environment, that's what they want.
Involved. The doctor doesn't know, with whom he's going to be dealing or she's going to be dealing with among the 2 or the 3 people who are named, and it becomes much more of a group situation, informal situation.
we have another question. Is it cost effective to spend more money upfront to purchase long-term health insurance that is costly, but the policy keeps up with inflation? Some people I know have purchased it and it covers $300 a day, but that may not be enough in another 30 years.
Right. All right. All right. Now all right. So when you're thinking about the policy, there are a number of factors within the policy that have an impact on the premium. You know, and that's one of them. There are two ways typically that policies have of that cost of living. One is called simple interest, which just adds, in this case, it would add 5% to the 300. Can't do the math that fast. $60.
$60, yeah.
Each year. Compound interest is where the first year it's 6% of the 300. The second year it's 6% of the 360. So it's compounding.
Mm-hmm.
That's much more expensive. So one way you can ask is there, do you have both ways of doing this? I'm interested in this. Can I build in less of an inflation protection? 3%. I'm willing to take some risks. I don't want to get skunked. And if you're getting this at age 55 versus 40, that's a different issue too about how concerned you're going to be about inflation. How long just a few other things on this. There's a waiting period, or they call it an elimination period.
An elimination
a period of time that has to pass before
Right.
they're going to start paying you anything. Now, you think the shorter is better, 30 days, but you can think about what the difference in the premium might be if you did it for like 6 months. And you looking at your finances, you have to ask yourself, well, if things really fell apart and I was going to go long term, I can afford 6 months. It's not going to impoverish me. I can't afford more than that. So I may not need this at all. I may die before the 6 months is up.
Don, in the time I've been working with long-term care insurance and that elimination period, we almost always have gotten people to qualify during that period. So
Yeah.
I've never seen that elimination period being a problem in activating a policy.
The policy.
Right.
The other things have to do with copays. There are other small provisions in the policy that can have a bearing on how expensive it is. But you have to do some really careful financial analysis when you've pared it down. You have to make sure that it's something that you can afford long term. You may be paying for it for years. You may not need it, and you can't. You have to also explore. Well, what happens if I can't pay for it? What are your provisions for? And this policies have to have this now.
Right. Or if they lapse. And the other thing that often happens is the client lets it lapse.
Right.
Right.
Rates are going up. They can't raise your policy, particularly because of your illness. They can raise it for the whole class of people that they're dealing with state approval. And that happens. But every time that happens, they send you a letter and they say that, well, we can cut your premium in half. We can eliminate the premium altogether.
Right. That happens. Yes. Right.
Reduce the amount of your benefits to what you've paid in or something like that.
Right.
They give you options so you don't have to give the whole thing up entirely.
I think this is our last question.
Okay.
Because it's 7:20. How financially aware should the legal financial guardian be, I think, and additionally the estate agent be? So, and Don, you might want to talk about the difference between a guardian and conservator here, because I see the word estate in this question.
Got it. Okay. All right. This terminology is actually, the meanings have changed.
Yes.
That's real good.
Right. Right. New definitions.
Broad brush, guardian is responsible for personal decisions like health care, like admission to a facility. Conservators deal with money matters. They're the money managers for the person. They're like a trustee, although the money still belongs to the person. This is just somebody who's been appointed with control over it. The standards for appointment are different. One's more oriented toward risks related to your inability to make important decisions about your life, and the other more about losing all of your money because you don't have any judgment about money matters. But that's the basic idea. When we talk about an estate, the term can be used generally to just refer to everything I've got. My estate means my
Right.
real estate means your real property, land and houses. Personal estate has to do with the stuff you own in the have in the bank and the stuff in your house. Uh, estate also has this meaning about after death. When we talk about settling an estate,
That's right. Yeah.
we think about what the person owned in his own name at the time of his death.
And what about their the conservator's extension after death, right?
Right, conservator ends at death. Power of attorney ends at death. Healthcare proxy ends at death. It's all over.
It's all terminated at that
Right.
point.
Part of the question too had to do with qualifications, and this is really important. I think the person, the guardian or the conservator, is charged with making the ultimate decision, but they don't have to make it on their own. They don't have to be in the blind about it. It's perfectly appropriate to use the person's resources to get the advice that you need to make what you're a comfortable decision. You don't have to do it yourself. You can place the funds with a financial manager. You can get advice on benefits and how to stretch the benefits out from a lawyer or from a social worker. And you don't, and you shouldn't. I mean, you shouldn't put yourself in the position of making a decision you're going to get criticized for. So either be very cautious or just get some advice.
Right. Any more questions? I think that does it for the questions.
One last one that I sent you, and it looks like someone's raising their hand. Just unmute yourself, Mary. Yep, just unmute yourself.
There you go.
Yes, I had a question in reference to a revocable living trust. I've been told two different things. One, to put everything I have in the revocable living trust. And then recently I've been told that if I have a 401k or IRAs or an annuity, it's better to leave it out of the trust and have beneficiaries, which those items can go to directly.
Yeah. No, I think the problem, hypothetically, you could put an IRA into a revocable trust, but the IRS would treat it as a taxable distribution. It would treat it as if you had withdrawn the entire IRA yourself, and that entire amount would be taxed to you in the year that you did it. You can't change the ownership of the IRA or the 401k, and putting it into a revocable trust, even though you control the trust, is considered by the IRS to be that change in ownership. So you can't do it. But you can put, the only things you can put into a revocable trust are things that you own outright in your own name. If you have a brokerage account separate from your retirement accounts, that can go into a revocable trust. Your house can go in. The people, and part of the issue has to do with avoiding probate. And that's maybe one of the reasons why they discuss this with you. And it's revocable trust is a useful tool for that. But it's revocable trust is one of the tools that's used. You can, for instance, if you have a brokerage account with Merrill Lynch or somebody, not a retirement account. Brokerage houses today have arrangements sort of like the beneficiary designation. They call it a payable on death or a transfer on death, POD or TOD. It's a form you fill out that instructs them on death to transfer whatever's in there into your revocable trust. That you can put in at your death, you can put it in the revocable trust, not the retirement accounts, but other things. And that can avoid probate. If that brokerage account is in your own name outright at your death, then you're going to need to probate the will to get it distributed. If you take the same brokerage account or savings account at Bank of America and fill out a TOD or a POD form with them, having it paid over to the revocable trust, then everything, at least everything except the retirement accounts, will all be pooled together in the revocable trust, and you'll avoid probate.
Okay. I think most of my accounts are just listed as the revocable
In
trust.
your own name. In your own name.
Yes,
Yeah, we'll
in
see
my
that.
name.
Yeah, so your will, what the will, when people talk about probate, what the whole concept is that, I mean, the problem is that there's this account you have with a brokerage house, and your name is on it, and you die. And the brokerage account, the broker has no idea what to do with that account. He can't turn it over to somebody who just comes in and says, I'm her daughter, it's mine. And the probate system is really in response to that problem of how does anybody figure out who owns that house when the owner has died? Is this the right will? Did they do a will? Do they have a will? If they didn't have a will, what statutes apply? So probate becomes necessary if you have those assets. One way of avoiding it is to go and put them in joint name. That has its own risks. This is actually one of the papers I have talks. I think it was last
time. Yeah.
last one goes into a lot of this. If you have that, you can ask. If you don't have that paper, there's a whole discussion about all of this
Right.
stuff, the POD,
The probate, right.
probate, and how to avoid it. All of that. There's a big section in the paper. If you ask Tracy if you don't have it for last month's paper, she'll send it to you.
Okay.
Okay.
All right.
The
Thank you.
is right. I mean, if it's in the retirement accounts, can't go into the revocable trust.
Well, let me ask you quickly one other question. The revocable living trust was made in 1991, and it has been updated, twice.
Yeah.
But it was made by an attorney in Missouri, which is where I lived previously. And I understood that would be honored anywhere.
Well, the two, yeah. Well, all right. There's a general rule. It's from the U.S. Constitution that says basically that an instrument like a trust, which is legally valid in the state where it's executed, should be given full faith and credit in other states. In other words, it should be treated as valid.
Okay.
Now, that doesn't get you all the way home, though. What valid means is that even though Missouri required only one witness and Massachusetts requires two, they'll ignore that fact. But whether the terms themselves, the provisions in it, create any problems because of differences in the definitions of terms between the two states as to what kind of property is involved, or by what right of representation means, it's potentially a problem. What I always recommend to clients when they move out of state is that they may not have to make any changes in their instruments. They may be fine, but have somebody at least look at it to see whether there is a problem there that can be covered.
That's a very good question about moving state to state, because we have lots of folks who do move. Seniors do move to be closer to family.
Yeah.
Tracy, I think we have another question.
Thank you.
No more on the chat. I think I sent you one. Do you want to just ask that?
How does an adult child protect a parent with Alzheimer's if the parent lives alone? I've heard of so many cases with elders giving away money. Are you talking?
Right.
Yeah. Are you talking about elder scams now, or just overly generous people?
I think as they age, they're
This is a capacity issue.
savvy. Yeah.
All right. There's a span. There's a kind of a continuum of what goes
That's
on.
right.
In these
There's an
situations.
array, right?
Right.
I can tell you some of the practical things.
The criminal end. Yeah. So, I mean, depending on the circumstance, let's focus on the prevention issue. But just briefly, there's fraud and larceny and things like that. At one extreme, where you go to the police. At the other extreme are situations where the person is just is more generous than you would like. You think maybe impractically so, but this is the way she's always been, and it's probably not much you're going to be able to do.
It's more like it now.
Right.
More of it now.
The person's judgment is really impaired about them to the extent that you're seeing her assets be dissipated. then there are steps that you can try to take with her if she will allow you into the management of it, with a over things. You may need a conservator in that situation. There's also a set of procedures available through the state home care program. These are the nonprofit agencies like Springwell in our area,
Right.
that deal with this issue quite a bit. There are laws to protect people who are neglectful. It's called self-neglect, where they just can't take care of themselves or can't take care of their finances. The agency has supportive services that it can put into play, can actually bring in a guardian, a professional guardian if necessary, or a conservator, or have money management. There's another category of stuff in the middle here called financial victimization. This is where there's concern that, not the case you're presenting, but I'm talking about the range of things where there's concern maybe by one child that another child is taking advantage of the mom's situation and is really exercising undue pressure or threatening withdrawal of affection or withdrawal of support or help in the interest of the child's own financial interest. Unfortunately, this does happen, and really this is something also that Springwell or the other agencies have legal authority to intervene in, or you may want to talk to a lawyer about it.
And I think the Massachusetts Executive Office of Elder Affairs has a pretty active program now to protect seniors. And I think actually some of the local banks and even the larger banks are aware of this now and do work with families around these issues. So if mom is buying lots of raffle tickets, maybe more than she should, and she's using a credit card to do so, sometimes the banks will work with you if there is an elder at risk.
I can tell you that Bank of America worked with me with
Yes.
one of my parents. There was an issue with the safe deposit key that my mom was carrying in her pocketbook and it was risky.
Yeah.
So
actually, the Bank of America, believe it or not, has a very large elder consumer department.
They actually
they've made it a priority.
They made a dummy key. They put alerts, so they were wonderful in working.
Yeah,
with this, so.
BOA is actually pretty good with seniors.
One of the resources, just quickly mentioned Springwell. So the Executive Office of Elder Affairs, a state agency, operates, it's called protective services, the things we're talking about, the agency doing to help protect elders from neglect or self-neglect or financial victimization. And the program is implemented through Series 36 or 39 nonprofit agencies with catchment areas all across the state. And well advised, if you're in the situation or if a parent in the situation, to familiarize yourselves with that resource, because it's a good source of information and referral. In the Newton Watertown area, it's Springwell, it's Somerville, Cambridge,
Ethos, West Roxbury.
Yeah. So it's it's a very useful resource.
I just sent you a text, but I can read it myself. Someone just mentioned that you can have a bank alert if a parent has withdrawals that are made or spouse above a certain amount.
Right. And the banks will actually work with you with credit cards and alerts as well, or ceilings. And, we have found actually that I had a client once who I think bought over $15,000 in magazine subscriptions because she kept forgetting that she had already purchased them. And we literally went back to that clearinghouse and were able to detail that she had medical disabilities and couldn't remember doing them, and we were able to get the money back.
There's one last question, so we'll finish now after this. Someone's asking, what is the name of the paper that you need to sign for the brokerage firm to protect your assets going to a child after someone has passed? This person says her account is in the name of her trust.
I'm not sure I understood the question.
It says, what is the name of the paper that you need to sign for the brokerage firm to protect your assets going to a child after you die? And this person wrote,
You mean you have assets and you want to make sure they go to that child?
Someone doesn't get them. Is that, I think that's it.
I mean, all right. So, well, if you, if that's the, if the, I mean, one thing that
It says my account is in the name of my trust. This
Oh.
account is in the name of her trust. She wants to know the name of the paper that you need to sign for a brokerage firm to protect your assets going to a child after you pass.
you know, the thing is that the trust terms themselves are going to control on the distribution. So if the assets are in the trust, then the trust, there's no other form. If the assets are in the trust, then the trust will control. Sometimes if people want to, generally they want to have equal shares going to their kids, but they want to give one a little extra. Sometimes what they will do is identify one account that they want to have go to that child directly, and they can go to the bank, and there are several different terms that are used: payable on death, transfer on death, or even in trust for, even though there's no trust. It's language that can be used in Massachusetts. If you use any of those forms with the bank, then and you've died, all the child has to do is show up with a death certificate and the money will be distributed directly. But it wouldn't be going through the trust.
I would say if anyone else has any questions after that, we're finishing now. If anyone has a question, email me and I can always forward it to Dawn or to Audrey.
Yeah, no, we'd be happy to try to respond.
Right.
It's always hard to answer questions without full understanding of all the circumstances.
The circumstances, yeah.
Facts that you're not, you realize that they're critically important, but it's, but we, at least on a general level, we can give you some information.
Well, thank you, both of you. This was a wonderful discussion, and I hope I've been getting some feedback on the chat. Some people had to leave earlier, but everyone really enjoyed. So thank you so much to both of you. I know Audrey and Dawn prepared countless hours to prepare for this series and all the sessions, and I really appreciate it. I also want to publicly acknowledge the Newton Senior Center. They've been promoting our programs as well, and I wanted to thank the Newton Senior Center. And I want to thank Sean, our tech person, as well, for helping. Our next session will be Tuesday evening, January 19th at 6:15 with guest speaker Joan Katz. She's a social worker, as well as Dawn and Audrey, entitled "Who Will Take Care of My Daughter After I'm Gone?" And it discusses special needs if you're a parent of a special needs adult child. So thank you everyone for attending. I really appreciate it. A few people have asked me for some of the prior emails and papers sent out, and I will email them now when we close. Thank you again, and we'll see everybody in January. Have a happy Hanukkah and a happy, healthy New Year to everybody.
Thank you, everybody. Thank you.
Good night, everyone. Be safe.
Bye-bye.